Now, for those of you who have been with us in the past, you know that we've typically tried to go through legislation with a bit of a worldview flavor to it, so you understand the worldview behind legislation, particularly legislation that we're working on. But I wanted to say tonight that the gravity of the situation, to be honest, that we're confronted with really requires us to be more intentional in talking about the worldview that we're dealing with than we've been in the past. And if we don't do that, to be honest, some of the legislation we'll be talking about won't make sense, or you won't appreciate why it's important, because on its face it might not look too glamorous. So with that as a little bit of background, I want to tell you that tonight we're going to do this. We're going to look at the worldview with which we're confronted. We're going to look at the outworking of that worldview in Tennessee. So we want to give you the big picture, then we want to show you what the picture looks like in Tennessee, which will then make the legislation that we're going to be talking about make more sense. Now, all four of the areas in which our organization is most interested, which is marriage, family, life, and religious liberty, have all been impacted by a little noticed, to be honest, little appreciated, revolutionary change in the worldview in the law. Most of these changes came about way before I was born, but I've begun to understand them, and it's important that you understand them because it's changing everything. The very nature of law itself has changed over the last 80 years, and that change in the nature and understanding of what law is now being used to change what it means to be human. It's changing our understanding of what it means to be human. And you have to appreciate that the change in those two things will necessarily change everything else. If you don't remember any of the details that I give you tonight, or Will and I give you tonight, hopefully you'll remember this image that I'm about to give you. I owe this analogy to a friend of mine, Jeff Schaefer with Alliance Defending Freedom, who in speaking with me several months ago, used this analogy, and I think it's appropriate. So here is the picture that I want to give you, and I hope you can see it well enough in here and online. But this is the Lifeway building and the Draper Tower. So assume that you're at work a couple of weeks ago. You hear this loud noise. You don't really think anything about it. A few minutes later, you feel a little bit of a loss of equilibrium, but you just keep plugging away business as usual. And then this is what you experience sitting safely tucked up in your office on the far right-hand corner of the building. I hope you get that picture in your mind. You see, you could be in one part of the building, hear the noise, a moment later feel the rumble and think nothing's really taking place. I'm going to go about business as usual, and the next thing you know, you're buried in concrete and steel. And that's what's happening in our country and in our state, and I'll show you how it is happening and why it's happening. But I hope that picture will stay with you. Because no matter how safe you feel being in a state with supermajorities of Republicans who profess to be Christians, and Republicans in every branch of the government being the majority, including the Attorney General's office, you are not safe. So let's start with the change in the understanding of what's going on in the law. There used to be this old view, I call it, that there existed this thing called pre-political, pre-governmental law. It was actually referred to as natural law, and most of y'all have probably heard that term. Christians have an understanding of natural law, but it's not been limited to a Christian understanding. Even Cicero, between the period of 51 to 54 BC, wrote on the Republic. And he talked about the fact that there is a natural law that applies to all people in all places at all times. And that natural law was the foundation for what we know of as the common law. Now, one of the great proponents of the common law in our country was a jurist by the name of Joseph Story. He was the youngest man ever nominated to the United States Supreme Court. He was a constitutional law professor at Harvard University. He wrote the first commentary on the Constitution of the United States. And so it's not surprising that we find Joseph Story writing probably the seminal case in constitutional law history on the issue of common law. It's a case called Swift v. Tyson. It was written in 1842. And this is what he said. The law respecting negotiable instruments. Now, for those of you who aren't business savvy, negotiable instruments would be things like checks, promissory notes, bills of lading, warehousing receipts, things you would use in the stream of commerce, paper you would use in the stream of commerce. He said, and it may be truly declared in the language, notice, of Cicero, adopted by Lord Mansfield, who was an English jurist, to be in great measure not the law of a single country, but of the commercial world. There shall not be, and here he begins to quote in Latin, and I translated it for you because my Latin's a little rusty, perhaps yours isn't, but this is quoting Cicero, or paraphrasing him. He says, there shall not be one law at Rome and another at Athens, not one law and now another hereafter, but also among all the races and all the time one and the same law. So the idea is that there is a law that exists over the whole of the planet that we did not create that applies to certain commercial transactions. The only law is not the positive enactments of a legislative body. There is a preceding law. But after Darwin's evolutionary theory came out in 1859 and began to work its way into other fields, including law, one of the first places was Harvard, the notion that there existed a pre-political, transcendent, natural law established by a creator had to go, because Darwin got rid of the creator. And so in 1938, the Supreme Court finally jettisoned the idea of Swift v. Tyson, articulated by Mr. Story, in a case called Erie Railroad versus Tompkins. It's a case that every lawyer reads and studies. I read it. But to be honest, nobody explained the worldview to me that was hidden in that case. And it is applying now, not just across the nation, but particularly to Tennessee, and is being advocated by our governor, by an increasing number of our legislators, and by our Attorney General, and most likely, they don't even realize they're doing it. And here's what the court said in Erie Railroad. The fallacy underlying the rule declared in Swift v. Tyson, that's the case we just quoted. It says there's a common law that applies to all people, all places, all over the world. It's not just coming from the legislature. It says that doctrine rests on the assumption that there's a transcendental body of law outside of any particular state, but obligatory within it, unless and until changed by a statute. The federal courts have the power to use their judgment as to what the rules of common law are. So there you see this notion of common law. Common law is rooted in the notion of the transcendent. And they're saying there isn't any transcendent thing out there. And notice what he says, but law in the sense in which courts speak of it today does not exist without some definite authority behind it. Now we have to appreciate what the court is saying there. There can be no natural law. There really can't be any transcendent common law because there's nothing definite behind it. Now you and I would say, well sure there is. There's God. But see, we've jettisoned that notion in the law. Or at least we've jettisoned the notion that that law is definite enough. Why? Because after Darwin we began to question the authority of the Scriptures, did we not? Can you remember a famous case in Tennessee in which the authority of the Scriptures was put at issue in 1925, 13 years before Erie Railroad? Yeah, the Scopes trial. So we can't have this idea. How would we know this law if there is even a God behind it? But let's go on to what the court next said. The common law, so far as it is enforced in a state, is not the common law generally. See, that was the old idea. There's a common law that applies everywhere. So no. It's just the common law of the state existing by the authority of the state without regard to what it might have been in England or anywhere else. Look at this statement. The authority, and the only authority, is the state. And for those of you who attended our Restoring the Vision, and by the way, we'll have another Restoring the Vision May the 5th here in Nashville, and let me encourage you to come if you haven't, or come back if you need to brush up on it. But if there's nothing transcendent, then law has to be just here. There's no place for any other source of law. And so the court says that therefore, the voice adopted by the state as to what the common law is should utter the last word. Now there's both good and bad in this statement. Let me note here, the bad perspective, it's a clear statement by the Supreme Court that there's no authority when it comes to law apart from the state. Okay, there are no transcendent inalienable rights, at least not at the federal level. If you want to know why the court has to find magical language in the Constitution to create a right, that's why. There can't be any other source of a right. So it has to come from the authority of the state or the government, and the Constitution serves that purpose. But now you understand why we have to have a living Constitution. Because if you're tied down to the words that are in the Constitution, you can't create new rights. And we've already said you can't have rights in a transcendent source, so we have to breathe life into the Constitution to bring in rights, and we root them in the Constitution, and that's what's going on in our court system. And why? What we've done is you don't abolish the transcendent, you make the Supreme Court transcendent. They become God. Now here's the good part. It's a foundation for hope in our state, and that is that the Erie Court says that it's none of our business to tell a state what its common law is. Common law of contracts or negotiable instruments or torts or whatever it might be, even marriage, it could be the common law of Tennessee, and Kentucky's could be different. And we have no business telling you what your common law is. And that's good. Because here's what the Supreme Court has said in connection with family law. And now we're going to begin to apply this to our specific areas of interest. The Supreme Court in 1877, now keep in mind, this is not too long after the Swift v. Tyson case, before Erie Railroad, they said this is based on the old view of law, that informal marriage by contract per verba de presente. Those of you who are Latin scholars are probably enjoying this evening, but I put the translation down on the bottom, which is words in the present. Informal marriage by contract by words of the present constitutes a marriage at common law. There can be no doubt. Marriage is everywhere regarded as a civil contract. Statutes in many of the states, it's true, regulate the mode of entering into it. Here's how you give expression to that. Notice what the court said. They do not confer the right. Why? Because it exists apart from the government. It precedes the government. It's grounded in a law that precedes the government. And you have that right. Now, what does that mean for us? Here's what it means. If our state officials are willing to consider getting out of the business of creating government licensed marriages, saying to you, you can't get married without my permission. Now, when you think about that, that does sound bad, doesn't it? I remember when my dad remarried after my mother passed away, and the minister said, let's go back and sign your license. And he said, what license? You had to have a license. Why did I have to get permission to get married? You know, that's what happens when you're older, right? You forget. I got to get the state's permission to get married. Well, if we got out of that and said, we're not going to license marriages anymore, but we are going to allow a man and a woman to exercise the God-given common law right to marry, and we will provide them a means by which they can file public notice that they've entered into that marriage, then we have rooted marriage outside the grip of the civil government and outside the grip of the Supreme Court. You see what I'm saying? We've rooted it in something other than the government. But we have an opportunity, a way to restore marriage in Tennessee if we're willing to do so. Now, what I want us to see in the next few minutes is that this rejection of the transcendent has been working its way into our marriage law and into our life issues for the last 50 years. In other words, Obergefell was not as big a groundbreaking decision as you might have thought it was. Okay? So I want to bring to your attention this case in 1965. The fruit of Erie Railroad began to show up, the rejection of the transcendent in family law in 1965. That case involved a state law governing the distribution of contraceptive devices to married couples, and the court struck it down. Probably a silly law, but they did. But in 1972, just 7 years later, the court explained what it did in Griswold. That time it was in connection with contraceptive devices being given to unmarried women. And here is what the court in 1972 said we did in 1965. Notice the worldview here. The marital couple is not an independent entity with a mind and heart of its own, but an association of two individuals, each with a separate intellect and emotional makeup. If the right of privacy means anything, it's the right of the individual, married or single, to be free from unwarranted government intrusion into matters so fundamentally affecting the person as the decision whether to bear or beget a child. Now let me interpret that for you. In other words, what the court is saying, when you deny the transcendent, there are no basis for transcendent realities. Doesn't exist, right? What does that mean when it comes to marriage? It means there's no real thing called marriage. Did you notice what they said? When a man and a woman come together, they don't create some separate entity. There's nothing that emerges from it. It's not that they go from a man and a woman into becoming one flesh, and they therefore have certain rights with respect to one another and duties with respect to each other. They're just two separate individuals, always remaining separate, just associated together. Now I confess, I didn't pick up on that, but I think I was 7 at the time. So I hold myself unaccountable. But if there's nothing transcendent, there's also can be no sanctity of marriage. It just can't be. Theologically, philosophically. So marriage only has the meaning that we ascribe to it. But I want you to appreciate this. Religion is a subjective issue now. There's no reality to it. There's nothing definite to it, right? We've already talked about that. So it can't be a claim to truth, which undermines any pre-political, pre-governmental right to religious liberty. You want to know why we're struggling with religious liberty? Because there is no right to religious liberty outside the civil government, because there can't be. There's nothing transcendent. We just have to fight for our elbow room. And because the only power is the state decides what part of your religion is okay and what part's not. And most of the time, we're fighting on the wrong grounds, letting them to define the grounds on which we get to defend our right to religious liberty. If we are unwilling to assert that there is any transcendent pre-political law, we're sunk. You're just sitting over here working in the Draper Tower thinking everything's fine and there's a lot of noise going on, but it's collapsing. So that's why it would be accurate to say that Obergefell didn't really introduce anything new, philosophically, about marriage at the constitutional level. It's just a creation of the state. Not a recognition by the state of any transcendent truth about the nature of marriage. So what Obergefell really did was it just extended the deconstruction of marriage as rooted in a transcendent reality by denying the male-female element. Where did that come from? We don't like that, right? That's all they did. But here is what is new about Obergefell that, to be honest, we haven't picked up on. We think, okay, that's marriage. We lost that. Let's move on. Nothing new. That's what most of our politicians are saying. It's where most of our churches are, most of our Christians are. We lost. Well, understand what they did do new is humanity has now been redefined in androgynous terms for the purpose of marriage. As Jeff Schaefer said to me a few weeks ago, he said, everybody who gets married after Obergefell has a same-sex marriage. It may be that your marriage has a man and a woman in it, but by definition, the only kind of marriage we have is one that has no sex in it. So we all have that kind of marriage now. Okay? The last logical impediment to constitutionalizing polygamy and polyandry is removed. It's just an association of individuals who are sexless. So there's no reason to have a male or female. Have two males, have two females, well, have three. Have some combination of them, you know, just like when you go get donuts. So this Obergefell decision is not just about same-sex marriage. And this androgynous humanity, understanding of man and woman, has poisonous fruit. Because all that flows from marriage now has to be redefined. It makes sense, doesn't it? If marriage is the definition to which all of our other laws regarding the family are based, when you change the definition of marriage, you change all the other laws. You have to. So, here's what's going to happen. Parentage, mother and father, must be redefined. Since Obergefell, noted law professors began writing, saying that being a parent is no longer related to biology. It relates to your intention to be a parent and the functions you carry out, and whether you carry out the functions that the state deems worthy to designate you as a parent. So appreciate, you must have essentially become a licensee as a parent. There's no transcendent grounding for parental rights. It's gone. Can't have it. There's nothing transcendent. Artificial creation of children is going to be required. Because marriage is sterile, but we got to have the fruit of marriage. So children become more like commodities. Things to be created to meet the needs of adults. And that philosophy is going to have a tremendous impact ultimately on the question of the sanctity of human life, not only because we've lost the possibility of sanctity with the loss of transcendent, but we don't know what it means to be human anymore either. So if you don't care about marriage, but you care about your rights as a parent, if you don't care about marriage, but you care about the life issue, you need to care about marriage. And if you don't understand what's going on. And most of us don't. Now, how's it working out in Tennessee? Here's how it's working out in Tennessee. There's a case called Witt v. Witt in Knoxville. We were involved in this lawsuit. And here was the question. What does the word husband mean? Now, I bet if I ask all of you, you look relatively intelligent, you would know what a husband is. Am I a husband? No. Would I ever? I mean, yes. Excuse me. Yeah, that confused you. See, you weren't paying attention. I didn't see anybody laugh until I caught myself. But here's the statute involved. It involved two women. A child born to a married woman as a result of artificial insemination with the consent of the married woman's husband is deemed to be the legitimate child of the husband and the wife. And the question is, well, what's a husband? And with the urging of the Attorney General, the court in Knoxville said, well, a husband can be a wife. We have another lawsuit going on in Bradley County. It's over our marriage license law called Green v. Simpson. And here's the relevant language in the statute. It says that licenses can only be issued to a male and female contracting parties. You know what the issue in the case is? What is a male and a female? Now that sounds silly, doesn't it? But the Attorney General says, no, the word male can include a female. Now how does he do this? Now, I'm not saying anything, and I know he's probably still watching unless he got tired, but I'm not saying anything here about our Attorney General that I haven't said in open court and in briefs. Our State Attorney General's office, not him personally, but his minions who work for him, who are advocating in these lawsuits, here's what the question is. In their briefs, they start using this. Notice, these statutes invoke gender-specific language. Notice that. Right off the bat, the Attorney General's office has embraced the modern use of the word gender, which is being used as a subjective psychological grounding of psychology rather than a biological reality. We don't want to use the word male and female and words associated with that. We're going to substitute the concept of gender. So how do we get to the idea that a male includes a female and a female includes a male? Well, he goes to a statute that says this. This is the title of the statute. It's in the general construction provisions of our code. And there's a section that deals with how do you treat the tense of verbs in statutes, and how do you treat gender, and how do you treat the number of words. So section 1 says that the past tense can include the present tense and vice versa, if it's not contrary to the intent of the statute. So we don't have to go through saying everything multiple ways. The last part, number of words, says, oh, the singular can include the plural and vice versa. So we don't have to go through saying he, so we don't have to go through saying person or persons. You get what we're talking about here? Okay. But the middle part, here's what it says. Words importing the masculine gender include the feminine and the neuter, except when the contrary intention is manifest. Now, I would say that the word male and female implies that there's a male and then there's something different from that called a female. There's so many things wrong with using this statute to interpret the word male to mean a female. But see, he says, well, see, words importing the masculine, male, can include the feminine. It's kind of like, well, that's correct. But now you have female and female. So all we can have is lesbian marriages. It doesn't say and vice versa, does it? And then I said this, and I confess, I was being a little bit of a smart aleck. My wife would forgive me, I hope. As I said, but if you want to know whether this is talking about biology or talking about grammar, ask yourself, when this was codified in 1858, what did they mean by neuter? Did the General Assembly, were they concerned in 1858 that if we use the word male in a statute, we might leave out the man who's been castrated, and he's a eunuch. He's been neutered. So we don't want to use the word male and leave out the eunuch, right? So we got to put the word neuter in there. Or we were afraid we'd use the word husband and we meant that the husband who had been a husband but now can't be because he's been neutered, right? So that's clearly referring to grammar, not biology. Now I want to say one last thing and then I got to end and we'll hand this over to Will. I would agree with our Attorney General that if you give the word male and female its natural meaning, that it means a man and a woman, then our statute is probably unconstitutional. But here's the point constitutionally. If your friends don't care a hoot about same-sex marriage or any of these other issues, when our Attorney General goes into court and says we can take a word that everybody in the room knows means a man, the common dictionary defines as a man, and we're going to say that it means a female so that we can keep a statute constitutional, we are violating the separation of powers, and we were inviting courts to rewrite words. And here's why that's so irritating. Will and I spend our days down on the Hill trying to pass statutes that have words in them. And if I don't know that my word means what everybody in the room thinks it means, then what's the point of passing the statute if somebody can say, oh, well, that doesn't mean that anymore, it means this. And how can I pass a statute in 1995 that refers to male and females only to find out later, when I voted for that statute in 1995, that it means females and females and males and females and females or males? And I didn't use any of those words. What was I supposed to say? This is a serious constitutional crisis being precipitated by our Attorney General and by our courts. And it has to stop. And that leads to the legislation that we're looking at. And Will Burns, who's our new Director of Public Policy, will be up here to regale you in just a moment with some exciting legislation.
I want to start out with a little bit of a civics lesson to address as we begin to discuss the legislation that's coming up. That because you're here, you have a greater, higher interest in things and much more educated in these areas. And so you know what the three branches of government and what their responsibilities are. You know, obviously you've got the executive branch who, administers the laws. You've got the judicial branch, and their role is strictly to interpret the laws. Not to do what David has told us we've got now, to where they're basically making new laws by virtue of these words here and there. And then, of course, you've got the legislature that establishes the laws. They are the ones that are actually supposed to be able to write the laws. The judiciary can say this is unconstitutional, this is not the way the law can be, but they can't say, so therefore this is what the law is. The legislature's got to do that. So we're going to try, we've got a couple of pieces of legislation that we think will help turn the ship a little bit in terms of the whole separation of powers issues, to keep the judiciary from going to the extremes that they're doing. And the first one deals with the opportunity for the General Assembly to join lawsuits, to intervene into lawsuits that have been filed. And the whole purpose of this is that we've got situations where private litigants are increasingly calling on the courts to effectively set public policy because of these new novel interpretations of the Constitution, or they have expanded rights that were never intended by the General Assembly. And those are the very kinds of things that David was talking about earlier. And so to do this, we filed a bill, Senate Bill 2655, that allows the General Assembly to intervene. Now, what the mechanism of that is that this can be done in one of two ways. Either the two speakers, the Speaker of the House and Speaker of the Senate, acting jointly, can intervene on the issue, or a majority of the members of both the House and the Senate will be able to intervene in the suit. And simply put, it puts in a mechanism so that the General Assembly can have its day in court to do one of two things. One, to argue for the constitutionality of statutes as written, or against the intent of a law based on the words, giving new meaning to words. So they can argue for the constitutionality of a statute, or argue against some argument that would create new rights, such as David was talking about earlier. Or they could intervene for the purpose of opposing the creation or expanding the constitutional statutory rights when the Attorney General does not oppose those. So that gives them two different options there. And of course, this can be done, it's important for more than just the reasons of marriage. I mean, this could be a case involving abortion. It could be a case involving virtually anything to allow the General Assembly to curb the activities of the judicial activism that's going on and eroding our separation of powers and taking away from the legislature their constitutional right to legislate. And so, then again, it's to maintain the proper separation of powers and to ensure that the rule of law is maintained. If you've got situations like Dave was talking about, if those continue to carry on, then it becomes where law means nothing. It can mean anything anybody says it is. And so that's the purpose behind that. The second legislation that's related to this is Senate Joint Resolution 88 by Senator Yeager. And this is a process by which he is seeking to amend the Constitution relative to the appointment of the Attorney General. Currently, the Attorney General is appointed by the Tennessee Supreme Court, 5 members. And this process is largely, well, they've got they'll have a comment opportunity where people, the bar association or individuals who are interested can comment relative to individuals being considered as Attorney General, but the vote itself is basically private. There's no record of that. Now, what this resolution would do, as originally written, would allow the General Assembly to make that selection. And they would make that selection the same way they select the Secretary of State, the Comptroller, and the Treasurer, and that is by a majority of both the House and Senate voting for that same person. So the whole idea is to bring accountability and openness to the process. Now, the current process has been in place since 1870, and I'm sure it worked for at a time, but over the years, the Supreme Court has got to the point where it is no longer subject to the direct election by the people. As you know, since I think 1984, 82, they were started on these confirmation, basically yes or no type of thing. So there's really, they're not accountable to the people the way the General Assembly would be accountable to the people in this election. So basically, it's a closed process, and there's no public vote. Now, probably one of the negative that has resulted is that Senator Yeager is entertaining an amendment to the process to where it really doesn't really have any real good effect, because it provides that the Supreme Court can nominate, they'll charge that the Supreme Court will nominate a person for the Attorney General, and in turn the General Assembly will vote to confirm or reject that candidate. And if they reject it, then the Supreme Court has to give them another option. Now, I think the one difference is that under the amended suggestion, it provides that the Supreme Court would have to make their vote in the open, and so that everybody knows which justice voted for which person. So, but still, from our perspective, it doesn't really solve the problem. You still got the Supreme Court, who is not accountable to the people in the same way that the General Assembly is, making these selections. So it will basically take until the 2022 governor's election for this thing to actually become implemented, if it passes this year. So it is a long process. The second category we're going to discuss is defending the schools that defend biological realities. And this is Senate Bill 2480, House Bill 2620, and it is sponsored by Senator Joey Hensley and Representative Andy Holt. And just to backtrack just a little bit, last year there was a bill for the Senate Education Committee that mandated that all public schools have a bathroom policy that is based on biological sex. Basically, got shut down without even a vote. What we've tried to come up with this time is a common sense approach to this issue. What this bill would call for is that the state attorney general, if a public school system has a bathroom policy that is based on biological sex, then, and if they get sued by somebody like the ACLU, then the Attorney General will represent that school system. We originally had something in the legislation that would also provide that their judgment, if they happen to lose, that the judgment would be covered. However, as much as we thought we had taken out anything that a reasonable person could object to on this issue, we found out that was not the case. This has already been quite controversial. The first two sponsors, the first House and Senate sponsors that we had agreed to handle this bill, backed out because of pressure or reasons that they'll have to share with you about. But in any event, there's just a lot of pushback still, even on this. What I think is truly is a common sense approach. If you've got a policy that says students go to the bathroom based on their biological sex, then if you get sued, we're going to represent you, because we don't want the ACLU or these other interest groups that are well funded bullying our school systems, because they know that school system will be inclined to want to settle the case just because they can't afford the cost of the litigation. So this is going to be this is intended to be just a little bit of an incentive. Now, another point that makes this thing a common sense approach, we also say that policy that is biologically based can include a provision that says you can make accommodations for those who choose not to use the bathroom based on their biological sex. You can have, a separate setup for those people. The key is being that all students are treated with respect and provided privacy. But still, we've already hit quite a bit of a roadblock, so we'll see how that plays out. And I think one thing that's come across is just the whole issue of whether the Attorney General can already do this. You may have read in the paper a couple weeks ago on this issue where supposedly there's this letter from the Attorney General that says that the Attorney General's office, already had the authority to represent these local school boards on this issue. Well, that is just not correct. That's just the nicest way I know how to say it. I've confirmed this with folks at the Attorney General's office, and the authority that they've got, what they said they would do would be to assist the school systems in such lawsuits, but that would not keep them from having to have someone to actually represent them. As a situation in Sumner County, similar in this situation, the Attorney General assisted Sumner County Board of Education on this lawsuit or complaint that was filed, but they had to hire their own lawyer and spent hundreds of thousands of dollars relative to that. So it's a relevant issue. We think it's important, and we hope that things turn around. Oh yeah, and another important point. Again, this does not require anybody to have a policy on anything. You know, the legislation doesn't say you have to have this. It just says that if you do, this is what the process will be. The next bill, real quickly, I've run quickly out of my time, is a Business Protection Act. Long story short, this bill would prohibit a state or local government taking discriminatory action against a business on the basis of that business's personnel policies, as long as those policies were consistent with state and federal law. So that is to say that if ABC Corporation was applying to the city of Murfreesboro for a contract, the city of Murfreesboro could not discriminate on them, against them, because perhaps their policy for family leave was not as expansive as they wanted it to be. So basically there's four areas: anywhere with employee benefits, wages, family leave, and anti-discrimination policies. If you meet those state standards, when you apply for a grant, you put in for a contract, you can't be discriminated because you don't have higher standards than what that state says. Because what we fear is that these cities will basically say, well, this is what you have to do to operate, but if you really want this contract, you also have to have a personnel policy that says this or that, which is beyond the state law. So this is trying to protect against that as well. There are two bills that would seek to limit or prevent Planned Parenthood from getting state funding, one of which deals with Title X funds, and these are the family planning funds, things such as contraception, breast and cervical examinations, things such as that. And basically, it provides that it would implement a standard that the Haslam administration has used, but it's not in policy, it's not in statute, that basically would prioritize those entities that receive that money. And basically the type of institutions like Planned Parenthood would be in that last category, that would basically be entitled to it only if there was no other entity in that county that could provide those fundings. And then lastly, there is a bill relative to Medicare and Medicaid funds. And it provides, if the bill is passed, it would direct the Commissioner of Finance and Administration to submit a waiver to the federal government, giving them the authority to deny payment to or the use of entities that promote or encourage abortions, and whether that money would go either directly or indirectly to them. It would limit and prohibit those funds as well. And again, all that for the purpose of ensuring that entities like Planned Parenthood, whose main purpose is the promotion of abortion, not be the beneficiary of state funding. So with that, we'll go to the question and answering period.
Okay, here is an interesting question. Does the state legislature have the authority to dictate to the courts their jurisdiction on cases outside those listed in the state constitution? And how does that impact Senate Bill 2655? Now, I'm not sure I remember what, is that one of our bills, 2655? Yeah. Oh, okay. Yeah. Just real quickly, either of us could answer this question, but the state constitution does give the state legislature the authority to set the jurisdiction of state courts. And one of the things that's been interesting in this marriage case, you were talking about the redefinition of male and female in the marriage licensing statute. When the 81% of the citizens went to the ballot in 2006, you voted for an amendment to define marriage, but you also put into that constitutional amendment that said any judicial interpretation which purports to define marriage as anything other than a man and a woman is against the public policy of the state and is void and unenforceable. So my first argument about the Attorney General was you can say whatever you want to say what a male means, and the court can believe whatever it wants to believe, but it has no authority to interpret the word male in such a way as to purport to define marriage as a man and a woman, because the people took away the jurisdiction from the court to make that decision and vested it in the legislature, an argument to which there was no response. Now, I guess the judges can disregard that too if they want to, but anyway, Will, why don't you take a look and see if there's a question you want to try to answer on here. And I tell you, your questions really do encourage me, because I thought I was the only person with bad handwriting. This looks like some of y'all dictated these in your iPhone, and it came out sort of gobbledygooky, you know. But is there any real hope of stemming the tide of secularism and humanists who view, apart from a great spiritual revival? The general population seems to be either overwhelmingly ignorant or apathetic, so how can we expect to see people elected to embrace Judeo-Christian values? Because our hope is a living hope. Until the trumpet sounds, I play the game. And I expect God to do what He said, which is, I'll never forget my covenant people. I will keep my promises. And I can be very discouraged at times, but only because I think we're living in a period of time, not unlike other periods of time, where God is in the process of shaking things up that He might bring about something greater. Now that might mess with some people's eschatology, but I'm not quitting. I'm not giving up, and I'm pressing forward with hope. Part of what we're doing is educating people so that they do understand. We've got a huge job to do. Somebody suggested to me the other day, said maybe you need to change the name of Restoring the Vision to Rebuilding the Foundation. And I said that would be great, but we got to have a vision first that we need to do something with the foundation. Then we need to build it. We've lost this sense that God is concerned about the here and now, and He wants to say Jesus is Lord over all things here and now. So I'm not giving up hope. Go ahead, Will.
Well, there's this question relative to our bill 2655, which authorizes the legislature to intervene in lawsuits. It says, how confident are you that the Speaker will have the ability to remedy the judicial activism through this bill? And I gather from that they mean the speakers or the General Assembly, whichever route goes to intervene. There's no guarantees about anything. I think the way we approach this is that this is a great first step. This will give the legislature a voice to do something to ensure that their intent is implemented, or at least make that argument before the courts. Is that guaranteed to totally turn the tide? No. But this is just the first piece of a bigger agenda. We need to take, and this is kind of taking a page out of the opposition's playbook. We need to take small victories, get them where we can, and then build on that. And I think this is one of those items.
First thing is you need to have your day in court. Right now we're being excluded. Legislators tried to intervene in both of those lawsuits, and the court said no. Now, if we had a statute, they couldn't say no. We'd have a right to do it. I want to answer this question because it's a little off topic for us, but it relates to the last question. Could there be any other legal challenges to Amendment 1, or are we finally able to say we have the protections for women and the unborn? For those of you who remember, in 2014, the people passed Amendment 1 on the ballot to reverse the state Supreme Court decision, Planned Parenthood versus Sundquist. After 17 years, we got it through the ballot. The Sixth Circuit said the vote was constitutional, it's appropriate. I did learn that the opponents of that have filed a petition for an en banc review, which means the whole Sixth Circuit would review the case. I don't think they will, because the decision was 3-0 in our favor, including the vote of a Clinton appointee. But even if they do hear it en banc, I think the opinion of the majority of those 3 judges was so strong that it's not going to change the result. And I do not think the Supreme Court of the United States will take the case, because it turns on a very unusual provision in our state constitution that doesn't apply anywhere else. So why would they want to hear a case that doesn't apply anywhere outside the state of Tennessee? But let me just mention there, in regard to this last question, you know, I take no pride in saying this. I just happened to be there in the legislature when that decision came out and filed that amendment in 2001. It had to have 2/3 of the General Assembly approve it to go on the ballot. At the time, the pro-abortion party controlled 59 of 99 seats. We had to have 66 seats, and they held 59. If you looked at it from a human perspective, you'd say, David, that's stupid, you're wasting your time. The whole General Assembly would have to shift, and have to shift monumentally. Go work on something else. And I said, no, babies are dying. And the Lord changed the General Assembly over time. And then we got it on the ballot. And we got outspent 2-1. And it still passed. And then the court upheld it. Why do I fight? Why do we fight about marriage? Because we're stupid and we're titillating windmills, for the same reason that babies are now about to be protected in the state of Tennessee. Do not give up on God. Don't give up on Him.